You do it constantly. You tap I agree. You do not read it. Almost no one does. And buried in that fine print again and again is a single clause that can quietly take away two of your most basic legal rights. The right to take the company to court and the right to join with everyone else they treated the same way. In 2011, a fight over about $30 turned that clause into the law of the land. The clause is an arbitration agreement. It says that if you have a dispute, you will not sue in a public court. You will take it to a private arbitrator, one customer at a time. And it usually adds a second piece, a class action waiver, a promise that you will never band together with other people who were harmed the same way. This is one of the most consequential and most argued about features of modern American law, and reasonable people strongly disagree about whether it is fair. Over the next 12 minutes, the $30 case that made it enforceable, what the court actually decided, and the honest arguments on both sides. It starts with a couple in California, Vincent and Liza Concepcion. They sign up with AT&T for cell phones advertised as free. Then the bill comes, and they have been charged about $30 in sales tax on those free phones. $30. On its own, it is nothing. No lawyer on earth takes a $30 case, and that is exactly the point that makes this story matter, because the Concepcions were not the only customer charged that tax. If a company charges $30 too much to one person, it is a rounding error. If it charges $30 too much to millions of people, it is tens of millions of dollars. And now it is worth fighting. The tool for that fight is the class action, a single lawsuit that bundles together everyone with the same small claim, so that harms too tiny to sue over individually can be challenged all at once. The Concepcions wanted to bring one, but their AT&T contract said no. It required any dispute to go to individual arbitration, and it specifically waived class actions. So the legal question became, is that waiver enforceable? California had a rule from a case called Discover Bank that treated these class action waivers in consumer contracts as unconscionable and refused to enforce them. Under California law, the Concepcions could keep their class action. AT&T argued that California rule had to give way to a much older federal law, and so a dispute over $30 in phone tax became a case about who gets to decide whether you can ever join a class action at all. To understand the case, you have to understand two things: a 1925 law and one small, powerful sentence. The 1925 law is the Federal Arbitration Act. It was passed to make arbitration agreements enforceable, reflecting a federal policy that favors arbitration. The idea that if two parties agree to resolve disputes privately, courts should hold them to it. For most of its life, that law lived quietly. Then companies began writing arbitration clauses into the everyday contracts ordinary people sign for phones, banks, credit cards, and jobs. And here is what makes them so easy to miss. You do not sign these clauses with a pen at a desk. You accept them by activating a phone, opening an account, clicking a box, or showing up for your first day of work. The law treats that as a real agreement, and for the most part, the terms are not up for negotiation. It is take it or leave it, and leaving it can mean going without the service or the job. The powerful sentence is the class action waiver. Arbitration by itself just changes the venue. court versus a private arbitrator. The waiver does something more. It forces every claim to be brought one person at a time. And for the small scattered harms we just described, one person at a time can mean in practice, no one at all, because no individual claim is large enough to pursue. This is where honest people split, and it is worth hearing both sides plainly. Critics argue that mandatory arbitration with class action waivers, what they call forced arbitration, can quietly close the courthouse door, leaving widespread small harms with no realistic remedy, decided in private proceedings that set no public precedent. Defenders argue the opposite, that arbitration is generally faster, cheaper, and less formal than a lawsuit, that the 1925 law reflects a long-standing policy of honoring agreements people make, and that individual claimants can sometimes do as well or better than they would in a crowded court. Those empirical claims about cost, speed, and outcomes are genuinely disputed, and we are not going to pretend one side has settled them. The case is about who decides. In 2011, the Supreme Court sided with AT&T. By a vote of 5-4, it held that the Federal Arbitration Act preempts California's rule that a state cannot refuse to enforce a class action waiver just because it finds the waiver unfair. If the contract says individual arbitration it is. The opinion was written by Justice Antonin Scalia. A state rule that singles out arbitration's class action waivers and blocks them, he reasoned, stands as an obstacle to the federal policy favoring arbitration, and so it cannot stand. The federal law wins. Justice Stephen Breyer wrote the dissent, and it put the other half of the problem into words. For claims worth only a few dollars each, he argued, the class action is often the only realistic way to hold a large company accountable at all. Take it away, and you have not just changed the form, you may have ended the case before it starts. That 5-4 split did not settle the country's mind, but it settled the law. And 7 years later, the court extended it into the one place most adults spend their days: work. In Epic Systems versus Lewis in 2018, by another 5-4 vote, with Justice Neil Gorsuch writing, the court held that employers too can require employees to arbitrate individually and waive class or collective actions, and that doing so does not violate federal labor law. The same logic that governed your phone contract now governs your job. Epic was not a quiet decision either. Justice Ruth Bader Ginsburg wrote a forceful dissent, arguing that forcing employees to face their employer one at a time ignored the very reason federal law lets workers act together. And she read part of it aloud from the bench, a step justices reserve for the rulings they most strongly oppose. So here is where it leaves you. Mandatory arbitration clauses with class action waivers are now a standard feature of American life. In the contracts for your phone, your bank account, your streaming apps, and very often your employment. You have almost certainly agreed to several of them by doing nothing more than using a service or starting a job. Whether that is a good thing depends on which argument you find more convincing, and that is a real debate, not a settled one. What is not in dispute is the mechanism. Two ordinary rights, to sue in open court and to join with others, are now for most people waivable by a sentence almost no one reads. What can you actually do about it? Honestly, not much in the moment. The terms are rarely negotiable. But the argument itself is not over. Lawmakers, regulators, and companies keep fighting over where mandatory arbitration should apply and where it should not, especially for the most serious kinds of claims. The line this series keeps chasing is, here too, still being drawn. And notice what makes this different from everything else in this series. No officer took anything. No school punished anyone. The power here was handed over voluntarily in the most ordinary act of modern life, tapping a button to make a screen go away. A $30 charge on a free phone ended up drawing one of the quietest but widest lines in modern law. The line between the rights you have and the rights you can sign away without realizing it. The court did not take those rights from you. It said you were free to give them up. The fine print did the rest. We have now watched the state search you, track you, take your property, and police your speech, and watched you hand over rights yourself by contract. In every case, the same question keeps returning in a new costume. Where is the line, and who gets to move it? The next case moves that question somewhere more intimate than a phone or a contract. Not what you carry or what you sign, but what is inside your body. When the police arrest you, before any trial, before any conviction, can they take a sample of your DNA and keep it? That is next time.